Thank you very much, Phil. Thanks everyone for joining us this morning for an educational session. I'll call to order the CERS Board of Trustees and hand the gavel off to Ms. Hampton for the KRS Board.
Thank you, Betty, and welcome everybody, and thanks for all the preparation and the last minute Zoom emergencies. And I'd like to call the KRS Board meeting to order.
What's next on
The legal public statement.
Okay, so I'll read the legal public statement now. So for the record, I want to note that this is a special meeting of the County Employees Retirement Systems and the Kentucky Retirement System Boards of Trustees. This meeting is being broadcast via video teleconference pursuant to Kentucky Revised Statute section 61.826 and may be viewed by the public at the Kentucky Public Pensions Authority offices located at 1260 Louisville Road in Frankfort, Kentucky. It is also being broadcast to the public via Facebook. I ask if you are speaking and not appearing by video, please identify yourself before talking. In the event the video or audio broadcast is interrupted, we will attempt to reestablish a connection. If a connection cannot be reestablished within 30 minutes, the meeting will be adjourned and rescheduled to another date. Thank you.
Oh, just 1 second. Sorry, I've got people still coming.
That's okay.
Okay, so now we will start with the roll call, and I'll begin with the CERS Board of Trustees. Ms. Pendergrass,
Here.
Dr. Carver, Mr. Cheatham, Mr. Foster, let's get started. Mr. Fulkerson,
Here.
Dr. Hackbart,
Here.
Dr. Milkman, Mr. O'Mara,
Here.
Mr. Powell.
Here.
Thank you.
Sherry, I'm here. This is Pat Carver.
Oh, okay. Thank you, Dr. Carter.
Thank you.
And now for the KRS Board of Trustees, Ms. Hampton,
Here.
Mr. Adkins, Ms. Bova,
Here.
Ms. Eves, Mr. Lane,
Here.
Dr. Miller,
Here.
Mr. Piercy, Mr. Summers,
Here.
and Ms. Thompson. I do want to note, I do see Mr. Foster is on the screen. So, Mr. Foster, are you with us?
I am.
All right, thank you. I'll mark you present.
Legacy free binder.
Okay.
Are you ready? All right. I am going to stand up just because talking sitting down for too long it doesn't really work too well for me, and I think I feel a little more comfortable standing. Sherry is going to switch over to the presentation now, and I'm using a remote clicker to do this, and so if I actually click somewhere and it doesn't work, I apologize. I have to click it towards Sherry's computer because that's where the PowerPoint presentation is being run, and so it may take me a minute just to recall to do that. So welcome, and thank you all for being here this morning. I know we're in the middle of a busy season of committee meetings and board meetings, and I'm asking you all to give another couple hours of your time for this training, and I really do appreciate it. And so this training is something that we've entitled The Anatomy of a Civil Lawsuit. And I developed this training out of just a series of questions I received I've been here a little over 2 years. And throughout my time here, I would consistently receive questions along the lines of, well, when does this happen? And what's going to happen next? And what are we doing in this particular situation? And what does that mean? When I would give a litigation update in closed session and talking about some of our specific litigation, and I would get all these questions and I would answer them in relation to that specific litigation. But as a result of getting all those questions, I thought it may be helpful to put something together to help the trustees and anybody else that's attending to understand how a lawsuit begins and the process it goes through until we reach the end, and just to help the trustees maybe get a better framework and an understanding of the major stages of a lawsuit and the framework that we move through, help them get that understanding. And so when I'm providing the litigation updates in closed session and we're talking about some of our specific litigation, and I say we're doing this or we're engaged in that right now, they will understand and you guys can understand that's where we are. Along this continuum of a process, this is where we are at that moment in time. And we always talk about litigation being lengthy and complex and expensive, and this will help explain some of the reasons as we move through this. So just as a caution, we're in a public setting, we're in a public meeting, we're not in closed session. We're not going to talk about any of our specific litigation because of that. So if you have any questions, I'm happy to answer them, but we can't talk about our specific litigation in this setting. Those are closed session discussions. So before we get going, I know you all know me, but you may not know how I ended up here at KPPA. So just a brief couple of minutes on that. I graduated law school in 2008. I went to work immediately for the Bell County Commonwealth Attorney's Office. I was there as the Assistant Commonwealth Attorney for about a year. And then I wanted to come back to Central Kentucky. Bell County, if you're familiar with Kentucky geography, is a small county in the southeastern part of the state. And I was born in Harlan County, but moved away when I was 7. So I wanted to come back to Central Kentucky where I grew up. So I took a job back in Richmond where my family lives still. And I worked there for what is known as AppleRed. It's Appalachian Research and Defense Fund. And they are a legal aid clinic representing low-income families in civil matters. I did that for about 2.5 years. And then I was planning to get married and needed to find a job where I was earning a little bit more money. And so I came to work for the state government here in Frankfort, and I worked for the Cabinet for Health and Family Services. I was there as a staff attorney in their Office of Legal Services for about 18 months. And the opportunity came to switch over to be an administrative hearing officer there. I did that for 4 years. While I was there, I was asked to apply and was ultimately hired as the general counsel for the Executive Branch Ethics Commission. And I was there for 4 years. And then the opportunity came to apply here, and I did that, and I've been here for just over 2 years. So that's kind of how I came to be here. And so jumping right into the training now, from a 30,000 foot view, a civil lawsuit looks pretty basic. It looks like it may have just these 4 steps. We start off with pleadings, and we'll talk about what pleadings are and what goes into them. You get through the pleading stage and you jump into discovery, and discovery can be lengthy and time consuming. And then you reach a resolution and move on to appeal. And I have resolution before appeal because I'm talking about resolution at the trial court stage, not the ultimate ending of the case after appeals are all over, but the resolution of the trial court matter. And on that, between resolution and appeal, there can be a little bit of a circular pattern there because you think you've resolved it at the trial court stage and it gets appealed. And maybe what happened at the trial court stage is reversed and it gets kicked back down to the trial court. And you have to do something else there. So from a 30,000 foot view, it looks like, oh, there's these 4 simple stages. But over the next hour and a half or so, maybe up to 2 hours, we're going to break down these steps and look at their pretty intricate parts and understand why litigation is so lengthy and complex and expensive. So we'll start with pleadings. And pleadings is a pretty simple process. You start with a complaint and an answer. A plaintiff files a complaint and a defendant files an answer. And if it was that simple, lawsuits would move very quickly. But as you can probably guess, it's really never that simple. So let's talk about what goes in a complaint and what goes in an answer. So a complaint, what does it do? A complaint begins a civil action in circuit court. So you file your complaint and it starts off the civil action, and in the complaint, a plaintiff states their claim, what they want, and their demand for relief. And we'll look at a sample complaint in just a couple minutes and what goes into it. In some states, a complaint is a petition. In Kentucky, we call it a complaint, but in some states, they call it a petition. And then what does an answer do? In an answer, a defendant will address the merits of the case, of the claims in the complaint. They will also set out any defenses they believe they have to that. And if they have any counterclaims against the plaintiff, they will assert those. Typically, an answer has to be filed in 20 days from the time you are served with a complaint. So you get that service and you have 20 days to file your answer. Most of the time, when you get served with a complaint, the first thing that's going to happen is your attorney is going to reach out and negotiate a longer time. Because when you get a complex complaint, filing an actual answer to that is a little more difficult, and you probably can't do it in 20 days. Again, we're not going to talk about specific litigation to this agency, but if you can imagine working at a corporate entity who gets sued, and you get a complaint that may be 20 or 25 pages long with all these different allegations in it, then you have to respond to it. And when you respond to it, you have all these numbered paragraphs, and we'll look at that in just a minute, but what you have to do is either admit or deny the numbered paragraphs in the complaint. Well, if you're a corporate entity, one person may not be able to answer all of those things. And so you have to figure out who is the appropriate person to answer each one of these things in a complaint. That is going to be difficult to identify who the appropriate people are and then meet with them sufficiently to be able to answer that within 20 days. So you're going to immediately reach out to the attorney for the plaintiff and say, can we have longer time to do this? We need additional days to do this. You're going to get 30 days or 45 days or something like that to sufficiently respond. And so immediately getting served with a complaint, kind of everything else you're doing grinds to a halt. It's pushed to the back burner, and this takes precedent over everything else at that moment in time. So let's look at a sample complaint. I know this is a little small for the people in the room. I don't know if there's a place where we can see it a little bigger, so I apologize for that. But for those of you who are able to see what's on the screen here, this is a complaint, and my staff assistant, Beth Kamek, assisted me with putting together this slide deck, and she has a paralegal degree, and in her undergraduate, I think Beth actually drafted this as part of her coursework. And so this is just a sample complaint that she put together, and it's obviously fictitious, so you'll see it's Jane Goldilocks versus John Bear. And just for fun, this is in the Commonwealth of the Enchanted Kingdom in Forest County Circuit Court. So just to have a little fun with this drafting. So what does a complaint do? Well, first it identifies the parties, and in the section there labeled parties, it identifies that the plaintiff is Jane Goldilocks and the defendant is John Bear. It sets out where they live. Then you establish jurisdiction and venue, that we're in the proper court and we're in the proper location. So we're in circuit court and we're in the proper county. This is where we're supposed to be. You lay out your facts. What happened? And in this case, the facts is pretty short, but again, this is just a quick sample. And so Goldilocks is claiming that on a specific date, she suffered some injuries because she had some porridge that was very hot. And she suffered some injuries as a result of that. And then she puts out her legal claims that the injuries she suffered were because of the defendant John Bear's negligence, and those injuries are permanent and debilitating, and she also suffered emotional distress as a result of that. And so then you lay out your prayer for relief. And in her prayer for relief, what she's asking for here is a trial by jury, and she wants compensatory damages, and she wants punitive damages, and she wants all of her costs that are associated with this. So very simple, very rudimentary, but this is what a complaint would lay out in a civil lawsuit. And now we look at a sample answer. So if John Bear has to answer this, I'm going to bounce back and forth between these two slides for just a minute as we look through this. If you look at the first paragraph of the complaint where it says, "Comes now the plaintiff Jane Goldilocks," you'll notice it's not numbered. It's just by itself. In the answer, that first paragraph is numbered. Typically, you wouldn't number that paragraph. That's just the defendant saying, hey, this is me. I'm filing this as my answer. So that wouldn't be numbered. Also, you probably wouldn't put your defenses first. You would put them after you're responding to the allegations. And the reason you do that is if you look at line number 4 there, paragraph number 4, where it says the defendant admits to paragraph number 1 of the plaintiff's complaint. If you don't number paragraph number 1 up there and you move your defenses to the after this, what you have is that first what is paragraph number 4 becomes paragraph number 1, and then if you look back at the complaint, becomes a 1-to-1 match. So paragraph number 1 in your answer is admitting to paragraph number 1 in the complaint, and that makes it a very easy match across the two documents. So that's just a structural thing you do in your answer. You don't have to do it that way. It's just a little bit easier to respond to. But in an answer, you do these things. You respond to the allegations. You set out your defenses. If you have any counterclaims, you put them there, and then you also include your claims for relief or your prayer for relief. When you're responding to the allegations, you have to either admit them, deny them. You can do a combination of that. Or you can say, I lack information, and so I'm going to deny simply because I don't know. If I don't know enough to admit, I have to deny. And so just as an example, if you go back to paragraph number 1 of the complaint says, Jane Goldilocks resides and owns property, real estate at this specific address. Well, in this instance, John Bear admits the allegations in paragraph number 1. Well, what if he only knows that's where she lives, but he doesn't know whether she owns it? That may be something he's not aware of. In that case, he would say, I admit in part and deny in part.
Yes.
So he's admitting that she lives there, but he's denying that she owns it because he doesn't know that information. So you may have to do a combination of those things. So then you lay out, after you respond to the allegations, you would lay out your defenses, and then you would list counterclaims. Now, in this sample answer, I want to focus on the counterclaim paragraphs 4, 5, and 6. Paragraphs 1, 2, and 3 are more defenses than they are counterclaims. But if you look at paragraphs 4, 5, and 6 under counterclaims, what you'll see is that the plaintiff, John Bear, is alleging that the plaintiff trespassed on his property, and that as a result of that trespass, she damaged his fence and his window units, and now he's suffered financial loss. So in this case, he's saying, okay, whether she got injured or not by eating this hot porridge, I also have claims against Jane Goldilocks, and I'm going to assert those. So that in his prayer for relief, he is then asking that her complaint be dismissed, but then he's also saying he wants a trial by jury on his counterclaims, and he wants payment for his property damage, and he wants all of his costs. And so that's laying out a complaint and an answer in a civil lawsuit. Again, if it was this simple, it would go so much faster. But we know that isn't this simple, because in most lawsuits, before a defendant ever files an answer, they'll file a motion to dismiss. We'll talk about the standard for filing a motion to dismiss and what happened, what you're alleging in a motion to dismiss, and we'll talk about that a little bit later. But procedurally, the timing of this and what happens and what that does to the lawsuit, we'll talk about that right now. And so plaintiff will file their complaint. And then the defendant has 20 days to file an answer, or what we call a responsive pleading. Rather than filing an answer, like what we show up here, they're going to file a motion to dismiss. And in that motion to dismiss, they're going to ask the court to dismiss some or all of the plaintiff's claims. When they file that motion to dismiss, it tolls the time for filing an answer. So you don't have to file an answer right away. You filed your motion to dismiss. Your time for filing an answer is paused. You don't have to file it. So now we're going to deal with this motion to dismiss in this procedural process. So as a defendant, we get served with a complaint, and we immediately file a motion to dismiss. The plaintiff is going to have a chance to file a response to that, and then we're going to have a chance to file a reply to that. And so that process, just keep that in mind, because that's going to be a kind of a repetitive process. There's going to be a motion, a response, and a reply. That's going to kind of flow. That's going to be something we see repeatedly through this. Once all those documents are filed with the court's then going to look at the motion, evaluate it, evaluate the response, evaluate the reply. The court may grant oral arguments and ask the parties to come in and argue their points before the court. Then the court may say, no, I know enough of everything you put in writing. I don't need to hear from you all. We're good. And then the court's going to provide a ruling. And that can take a while when you're waiting on a court to rule. And then you get an answer from the court. You get your ruling from the court. And if the motion's granted, the motion to dismiss is granted, then the case is over, except the plaintiff may appeal to the Court of Appeals. And the plaintiff's going to say, Court of Appeals, the trial court dismissed this case. They shouldn't have dismissed it. I want you guys to look at it. If they deny the motion to dismiss, then in certain circumstances, the defendant can appeal that. Not all circumstances, but there are certain ones specifically applicable to state agencies. So I made note of that. So if they deny the motion to dismiss, the defendant in certain circumstances can appeal that, or they just have to file their answer and start up and move through that process now. So that's what's going to happen. So if we just talk about timing of this process. You file a motion, if we just pick a random date of January 1st that a complaint's filed. You know you're going to want to file a motion to dismiss. You're going to negotiate some additional time, get 30 to 45 days to file that. You're probably looking at mid-February when you file your motion to dismiss. Now the plaintiff is going to have time to respond. Give them 2 to 3 weeks to respond. We're in early March. You're going to have a week or so to file your reply. We're in late March. And then if the court's going to grant oral arguments, you're going to need a couple of weeks, maybe a month to get on the court's calendar for oral arguments. We're in mid to late April for that. And then we wait for a court's ruling. So from the time the complaint has been filed until we actually get oral arguments, we're 3 to 4 months into the litigation. And that's just getting oral arguments. Now we have to wait for a court's decision, which can take however long the court wants for a decision. And this is just on a motion to dismiss. So when we talk about the length of litigation, this is just the first step in showing why it takes so long to start moving through this process. I think I saw a hand raised.
Yeah, Ms.
So,
Hampton.
Ms. Hampton, did you have a question?
Yeah, and if it's going to be later, just tell me it'll be later.
Okay.
What's the difference between a motion to dismiss and a summary judgment?
We will talk about that a little bit later. We have a slide completely about that. So, but it's a great question. So, we get a decision from the court, and then that can be appealed. So, here's a little complexity that we've talked about, and we've got a lot of this flow charts here, and in just a few minutes you'll see a slide that gets really crazy with flow charts. I don't expect you all to follow it, but I kind of violated all the rules about slide decks with some of these flow charts, and I did that for a reason, because I really wanted you all to see the complexity that we can get into navigating these things. And that just follows the flow that we just talked about of how this could work. So you have the complaint, you have the motion to dismiss, a response, and we'll have a reply built in there. The court's going to evaluate the motion, get you a decision, and then if it's granted or denied, the various paths the plaintiff or defendant could take, and the result of those paths. And you'll see if the motion's denied and the defendant just files their answer, then we move on to discovery. And we've got a whole section we'll talk about discovery a little bit later. And we'll talk a little bit about appellate practice later as well, and what that looks like. So once we get up to the Court of Appeals, and while we're not going to dive into the appellate practice and what that looks like right now, we'll talk about that a little bit later. You'll get a decision from the Court of Appeals, and if they affirm the trial court's decision, and this flowchart assumes that the trial court granted the defendant's motion to dismiss. If they affirm that, then the plaintiff can decide, okay, I'm going to just accept that and the case is gone. Or the plaintiff can ask the Court of Appeals to reconsider. There's a thing called a motion to reconsider. It says, hey, Court of Appeals, I think you need to take another look at this. Or they can appeal to the Kentucky Supreme Court. If the Court of Appeals reverses the trial court and says, I know the trial court dismissed this case, but they should not have done that. This case needs to move forward. The defendant has the same exact options that the plaintiff has. They can take no action. If they do that, then you just go back to the trial court and you start up filing an answer and move through discovery. Or the defendant can do the other two things as well. Ask the Court of Appeals to reconsider or ask the Supreme Court to look at it. In Kentucky, if you appeal to the Court of Appeals, that is an appeal of right. You can do that. The Court of Appeals, unless there's a jurisdictional problem and they say, no, this case is not able to be appealed at this time, this is not an appealable order, and we'll talk about that a little bit later, they have to take the case. The Supreme Court is a completely different story. The Supreme Court has discretionary review. So the Supreme Court, you file what's known as a motion for discretionary review, telling the Supreme Court, this is a case we think you should look at. It has a unique question of law. There's special circumstances surrounding this case in which you should take a look at it. And they have discretion over whether they take it or not. They don't take a lot of them, but the ones they do take tend to be a little more complex, have a unique question of law in them, something like that. So if the court grants a motion, if the Supreme Court grants a motion for discretionary review, you jump into the whole practice that you're going to do before the Court of Appeals. You repeat it up there. And we'll talk about that process a little later. So let's just assume in our process that we've dealt with the motion to dismiss, and whatever the courts did, they did, but we're back in trial court and the defendant had to file their answer. So they filed their answer, and their answer included counterclaims. We talked about counterclaims earlier. Well, guess what happens now? The plaintiff can file a motion to dismiss the counterclaims. And now the defendant can respond to that motion and the plaintiff can reply to that motion to dismiss. The court may grant oral arguments, and then you're going to wait for a decision on that. And depending on the outcome, it can be appealed too. And so we're going through this entire process, and this is again just a sample answer with the counterclaims. So here's another route in the pleading process. So we have the complaint that's filed, and in that short little arrow between complaint and answer with counterclaims, we have the entire flow chart we looked at earlier, where there was the motion to dismiss and the response and reply, and you get the decision of the court, and you go up to the Court of Appeals and maybe the Supreme Court, but then you end up back here. All of that is encompassed in that short little arrow. Now we have an answer with counterclaims. And you get a motion to dismiss the counterclaims, and then we go through this process. The exact same thing we went through before. So if we put it all together, what started off as just, hey, you have a complaint, and then you go to an answer, all of a sudden, that morphs into this, and then it will morph into that, and then it morphs into this. And like I said, I don't expect you all to be able to follow this flow chart. And I know I violated all the rules of putting together slide decks and presentations by making this slide extremely busy. And I did it on purpose because what this demonstrates is all of this complexity and all of this time and all of the man hours put into drafting these motions and responding to these motions and replying to these motions and going to oral arguments and then taking this case up on appeal and doing the briefing at the appellate level. All of that stuff. We're doing all of that, and we haven't even started discovery. We haven't even actually got to a final defining of here's the complaint, and here's the answer that may or may not include counterclaims that clearly defines what we're fighting about here. We're just doing all of this to get to that point. So then we can say, based on clearly defining this fight, what can we do in discovery? What can we actually start taking discovery on? What's relevant? We haven't gotten there yet. And when we start talking about the time frames that come into play here, what we talk about is, in my experience, Court of Appeals, and I know we have some attorneys that are present, some attorneys that are trustees, so if you guys have different experiences, feel free to chime in and offer those here. But in my experience, case before the Court of Appeals, 12 to 18 months is going to be a quick case to go up to the Court of Appeals and get a decision and get whatever's going to happen there. If you want to take a case to the Supreme Court and you file your motion for discretionary review, if the Supreme Court says, no, we're not going to take the case, we're denying your motion for discretionary review, we're not going to hear it, whatever the Court of Appeals ruled, that's going to stand. That's going to take 6 to 9 months to get that kind of decision. If they do take the case up at the Supreme Court, probably looking at 2 years to go through the Supreme Court process and get a decision. Even though they take less cases, they do take the more complex cases. And so you're looking at a couple of years to get that decision. So when you take all those time frames and you put them all together, the big picture, what we end up with is in a worst case scenario where this flow chart comes into play and all this stuff happens this way, we could be 4 to 5 years into litigation before we even start discovery. And that's, we've spent man hours and money getting there. And that's just a lot of time and a lot of effort. And so I see Lynn ask a question about, does a criminal case have the same processes? They're similar. They're not the exact same. There are rules. There's rules of civil procedure and rules of criminal procedure, and they are different. When you go through discovery, distinctly is a difference in that as a prosecutor in a criminal case, you have an obligation to turn over evidence, even if it's going to be exculpatory to the defendant. That's one of the main things you have to turn over. There's a rule, if you don't do that, you can get in a ton of trouble for that. In a civil case, there's no obligation to turn that stuff over until the other side asks for it. So if the other side doesn't ask for discovery, you don't have to give them anything. And so there are some differences in the civil and the criminal process. Now I'm talking about state level, and in the federal courts there's some different rules even in the civil process. So I won't deal with the federal court side of things. We're talking about the state court level. So criminal cases do have some different processes. So now we get to talk about discovery. And I want to make sure I'm doing okay on time. And again, if you all have questions, please feel free to ask them now. If you want to save them for the end, either way, I'm going to plan on leaving enough time to have questions at the end, if you all have them. So let's talk about discovery a little bit. What is discovery? Discovery is the legal act of finding information previously unknown via freely given disclosures. It sounds like a lot of words. It's basically we get to find out stuff we didn't know before, and the other side has to tell us. So we can get discovery regarding matters that are relevant to the subject of pending litigation, or we can get information that is reasonably calculated to lead to the discovery of admissible evidence. And that's a very unique phrase, and what I always like to talk about when we get to this point is that we can discover a lot of things that are not going to be admissible if we end up in trial. And so I like to, for an analogy and maybe a visual tool to help people understand this, imagine having a funnel, and if you pour liquid in a funnel, ultimately all the liquid's going to come out the bottom. But if you put rocks in a funnel, you can fit a bunch of rocks of many sizes in the funnel, but only the smaller ones are going to come out the bottom. So with all the rocks you can fit in the funnel is what's discoverable. You can discover a lot of information. Only the rocks that come out the bottom, a much, much smaller amount, may be admissible at trial. So when we're going through discovery, we can find out a lot of information, but we can't always use all the information we find out because we have rules of evidence that are going to say, just because you know that doesn't mean you can use it at trial. And there's lots of reasons for that, that we just can't do that. And over years, the rules of evidence have developed and say, no, that's not right, that's not fair, that's not appropriate, we're not going to let you do that. So, and we're not going to get into the weeds on those sorts of things. If people have questions, I'm happy to answer those, but just as a brief and understanding that concept, that just because we know it doesn't mean we can use it. But discovery is open by default. So generally, if someone asks for information, it's going to have to be produced in some form. But there are some reasons that we can withhold information, and there's some privileges that can be claimed. So one of those privileges would be the attorney-client privilege or the attorney work product privilege. We can claim those and be able to withhold information based on those. Those are very specific things, and attorneys will dig into those when we believe they're applicable. One thing we can't do, however, is withhold information just because it's harmful to our case. You can't say, oh, well, that would really hurt our case if they knew it, so we're just not going to give it to them. Can't do that. Even though we might really, really want to do that, we can't. If they've asked for it and it doesn't fall into something we can claim as privileged, we have to give it to them. And so that's just something that can't be done. And so parties can object to the request, and we'll talk about some common objections in just a minute. We also, you can ask for a protective order, and we'll talk about how some of those are used. And you can ask for those to limit how sensitive information is used. So if you imagine two corporate entities that are having some litigation, and the subject of the litigation involves some proprietary information, some trade secrets, they're obviously not going to want that stuff out there in the public. And so they may go to the court and say, look, we understand we have to exchange this stuff with the other side because it is the actual subject matter of the litigation. It's relevant to what we're talking about. But we don't want it out there for everybody else. And so can we have a protective order that's going to govern this and govern how it can be used, how it can be publicized, and those sorts of things. So you can ask the court for something like that to help protect the information you're having to disclose. So some of the common objections that you're going to see: an objection that the requested information is not relevant. It just has nothing to do and is unrelated to the matter that we're here about. That's probably not going to be very successful because remember, if we talk about the funnel, you can fit a lot of stuff in that funnel. It's broad. So you're probably not going to be real successful claiming it's not relevant from a discovery standpoint. Now, whether it comes in at trial is a different issue, but from a discovery standpoint, probably not going to be so very successful because it's so broad. You're also going to see an unduly burdensome or overly broad objection. That's not going to relieve you from the requirement to produce a document or produce what's being asked for, but it will require the requester to narrow what they're asking for. And we'll look at some examples of some of these common types of discovery you see listed along the left side there. We'll look at some of those and we'll talk about some of these objections that may apply and how they work. But just imagine in this sense, if someone were to say, I want every document that a corporate entity has on this topic. Okay, well, you didn't give me, if it's between anybody, well, what about, can you limit it to the parties that might be involved in it? Can you give me some time frames that you want to put on it? So otherwise, I mean, what if the corporate entity's been around for 50, 60 years? That's a lot. That topic may have been discussed 40 years ago, and it has nothing to do with why we're here today. Can I have, so you're just saying, I will produce something, but you need to narrow your request a little bit. It's overly broad. And to produce that much information would be extremely burdensome. We just can't do that. So you make that objection. And then you have the vague or ambiguous, where we just don't know exactly what you're asking for. And we're not going to speculate about that and produce something that's not what you actually want or ask for and give you something that we don't have to give you. You need to be specific in what you want. And so those are some of your common objections. And so when you have discovery disputes, because you've objected to these, you have to find some way to resolve those disputes. Courts expect the parties to work together and not run to the court about every single dispute. They don't want you coming in there and fighting and filing a motion and getting in court every time there's a fight over something. Some courts will require the parties to do what they call a meet and confer before you can file a motion asking the court to resolve your dispute. You have to get together and try to hash this out amongst yourselves. And again, there's a note there about protective orders and how those can be useful in resolving some of these disputes. And as I mentioned, there's a big difference between something that's discoverable and something that's admissible. So now we're going to take some time and talk about the common discovery methods and what we go through. And just like we talked about early on, all of the time and man hours that can go into the process of a complaint being filed and the motion practice and all that goes into that, there's a lot of time and man hours that goes into the discovery process. And this can be extremely lengthy and extremely expensive for parties to go through. So the first one we're going to talk about is an interrogatory. And an interrogatory is a written question. It usually comes in a set of questions, 25 or so, that one party submits to an opposing party as a part of discovery. And I'll show you some sample interrogatories in just a minute. I'll go ahead and go to that slide. And again, for those in the room that may not be able to see this, interrogatories will start off with just one party saying, this is me, in this case the defendant, John Baer, is saying, I'm sending these to the plaintiff and subject to the appropriate rule of civil procedure, and I need the plaintiff to answer these. You'll provide definitions. If there's any terms you're using in your interrogatory that you don't want to just be defined by their everyday meaning, if they have a special meaning for this document, you have to define those terms. And then you provide instructions for how you want them answered. And then you have your interrogatories. So if you notice, interrogatory number 1 says, please provide your background. Well, at first glance, you go, what in the world does that mean? I'm going to use one of the common objections we have, and I'm going to object that is vague and ambiguous. I have no idea. Do they mean education background, work background? What are they talking about here? I don't know. But if we go back to the definitions, definition number 1 defines background for us in this document. And it defines it as the word background includes legal name, birth date, current residential address, marital status, employment address, employment position, and education level. Typically, those would all be in separate interrogatories. Or at least they would be lined out in one. Rather than using a definition like this, you would say, please provide this. So you're going to see interrogatories where you want all that information. That's going to be a common question you're going to get from everybody in discovery in this format. Some other common ones you're going to ask for is, I want the name of everybody who's going to help answer these questions. So typically, if you're a corporate entity, one person in your entity can't answer all these interrogatories. Just like with the answer, you're going to have to identify who can do it. In discovery, you're going to have to identify who can do it. And so they want the name of everybody that's going to help answer these. So you want to have their name, their position within the agency, within the entity. You're going to want to have that. And then they're also going to ask you to give us a list of people that you may call as a witness at the trial and what you expect their testimony will be about. That's a common interrogatory you get as well. So the next common type of discovery we have are request for admissions. And that is something where one party sends another party a factual statement and says, I need you to admit these. I want you to admit to this statement. And then the party that's receiving them has the option to admit, deny, or object to those written factual statements. Anything that is not denied is deemed to be admitted. So even if you don't say, I admit to this statement, if you don't deny it, it's deemed to be admitted, and it's not something that has to be proved at trial. So you have to treat these very carefully and make sure that you deny the ones that need to be denied. So we talked about, when we were talking about the answer, when you have to go back and admit and deny to those paragraphs in the answer, you're going to do the same things with these. And so a sample set of requests for admissions. So the first three on this, these are sent from the actual plaintiff in this case. Jane Goldilocks has sent these to John Bayer. And the first three are pretty simple. They asked the defendant to admit that the defendant was insured with State Farm, that the defendant had home insurance coverage, and then they asked to admit to the policy levels, to the policy limits. Those are pretty basic. You're going to get those admissions because those can be easily established by documents. So you're probably going to get admissions to those, unless the plaintiff is just way off base and didn't do their research and get those correct. Number 4 is where you're going to get your first major objection, a major deny, because the plaintiff says they want the defendant to admit that the personal injuries suffered by the plaintiff are the result of the defendant's negligence. Well, that's the whole point. That's the whole point of the case. There's no way the defendant's going to admit that. So that's a big deny in all caps. So you go through all of these and you admit or deny. Once again, just like with the answer and just like with interrogatories, if you're a corporate entity, one person probably can't handle all of these. They're just not going to have the subject matter knowledge, depending on how wide these are, how many different topics they cover. So you're going to have to spend time dealing with all these individual requests for admissions or interrogatories and figuring out who is the appropriate person within this entity to answer these, schedule meetings, and set up your meetings to meet with them. You may have to have multiple meetings with them to do that. And you'll see here at the top of this, they want these responses within 30 days. And that's the standard deadline to respond under the rules. Just standard practice, you're always going to get an extension if you request for one. Attorneys are always going to be willing to grant extensions to other parties because somewhere along the line, in this case or another case down the road, they're going to need an extension in something they're doing. And you don't want to play hardball and then not get that in return. So if one party reaches out and says, I know these are due on this date, but I need some additional time. Can I get an additional 30 or 60 days to respond to these? The other side's going to say, yes, take your time. You can have that time. And so you're going to get that.
We're talking about calendar days.
Typically, calendar days. Most people just work on the calendar days. And then we get to request for production. And this is where you talk about time consuming and expensive. this is where it gets really, really time consuming and expensive in discovery. And so a request for production is one party sends a request to another party and says, we want you to provide these specified documents, or maybe it's another tangible item. We want you to provide these to us. Now, as I mentioned, you can claim privilege over certain documents. You can say that document is subject to attorney-client privilege, or that document is attorney work product. We don't have to give it to you. But you have to actually go through the documents. So these are, like I said, very time consuming and very expensive to handle. So if we start with a sample of these, once again, we have a request from John Bayer to the plaintiff Goldilocks. They want them within 30 days. That's never going to happen in a request for production of documents. It's never going to be 30 days. Sometimes it can be a year when you're trying to deal with a massive amount of documents. And so you have your instructions, you have your terms, they define document for you, and then you have your actual request. And in this, you have the first one, they want all written, recorded, or signed statements of any person, including the plaintiff, witnesses, investigators, or any agent, representative, or employee of the plaintiff concerning the subject matter of this action. It's a pretty broad request. All written, recorded, or signed statements. Then the next one, they want all photographs, videotapes, or audio tapes, x-rays, diagrams, medical records, surveys, just all this broad information you want. When you're a corporate entity and you get a request for production of documents, there's a couple things you have to do right away. So you get a request for production, and one of the common ones you'll see is we want all documents, or all communications, this is more common, all communications between, within the agency on this topic in this time frame. First thing you have to do is identify between you're going to make 20, 25 of these requests for productions, what you might receive. You have to go through them all and identify who within your agency might possess relevant documents and responsive documents to this request. Those people are called in this process, they're called your custodians. They're your custodians of the documents. You have to identify who they are. They may still work for you, they may not work for you any longer. If they don't work for you any longer, you have to figure out what your agencies or your corporate entities' retention is of documents for people who no longer work for you. Do we still have them? Do we not have them? If we have them, where are they stored? So we have to identify who the custodians are. That can be a lengthy process. And more than likely, the requesting party and the responding party aren't going to agree on the proper list of custodians. The requesting party wants a very large and broad list of custodians. The responding party wants a much shorter and narrower list. Not because they want to withhold information. If you get caught withholding information in discovery, that can be very bad. But just the time and expense that goes into the broader the list. That's just, you want to have it as narrow as you can, tailor it, and still get all the responsive documents. So that's going to be somewhat of a battle that's going to take some time. So now that we've got our list of custodians, we know who those are. Now we have to develop a list of search terms, because we're not going to do this process manually. That's just ridiculous. We're going to try to do this process electronically. So we're going to develop a list of search terms that our IT department can use to run against all the places these documents might be. Emails, network drives, wherever they might be. We're going to run this against that. Run these search terms against the custodian's documents, wherever they may be stored. And so again, you're going to negotiate these search terms. The requesting party wants a very broad list. The responding party wants a very narrow list. Again, not because you want to withhold anything, you just want to make it as efficient as you can. So now we've got our custodians, we've got our search terms, and we've done that search, and we've produced a universe of documents that we have now that we believe may be responsive to these requests for production. You can't just turn them all over. Now comes a very labor-intensive process of reviewing these documents, because you have to go through them to see what's privileged. What's work product? And you can use some third-party vendors, some third-party software to assist you with that. But even using that, you don't just trust that it's done its job. You have to always go back and verify that. You have to go back and double check. Is it pulling the proper ones out for privilege reasons? Is it pulling the proper ones out for work product reasons? Is it leaving in the ones it's supposed to leave in so we don't get in trouble for not producing something we should have? So we have to do that. There's no other way to do that checking other than just man hours that you have to throw at it. And those man hours can be expensive. You have to do that. And then any documents that you do withhold. If you choose to withhold documents as a result of this and say these are privileged, this is work product, we're not going to turn those over, you have to tell the other side that you're doing that. You have to put those on what we call a privilege log. And in that privilege log, you provide a very general description of the document. Can't be too specific because the point is you're withholding it and not giving it to them. So you provide them a very general description and the reason you're not turning it over. And that privilege log will lead to fights with the court afterwards because the requesting party is going to say, no, you don't get to withhold that. No, you have to give that to us. And the providing party is going to say, no, we don't have to give that to you, and here's why. And then you're going to go to court and you're going to argue about it, and the judge is going to issue a ruling. And you're going to have to take that up. So this process, the request for production of documents, is one of the lengthiest processes in discovery because of, you may get tens of thousands, hundreds of thousands of documents that have to be handled through this process. And there's just no easy way to go about it. There's just not. And nobody will be willing to go through the next common discovery method until they have all the relevant documents. Because the next common discovery method is, did this stop working? Did. So I will ask Sherry if she can go to the next slide. There we go. So the next common discovery method is depositions. No one's going to want to go take a deposition if they don't have the universe of documents they need to have and have reviewed those documents to know what questions they might ask. Because a deposition is where you, you are taking a sworn, out-of-court oral testimony of a witness, of an opposing witness. And so you don't want to do that if you don't have your universe of documents and you haven't reviewed them thoroughly, and so you know what questions to ask what witnesses. And so you have to get through the other steps of the discovery process before you schedule depositions. And because the other discovery processes can take so long to get through, depositions are going to be at the very end. And it takes a while to get there. Parties typically won't depose their own witnesses. I don't ever say never in that sense. And the reason I never say never is during COVID, there was some legal scholarly writing that was recommending if you happen to have a witness or a client that is in a group of individuals who might be particularly susceptible to COVID and what's going on with that, you might want to get their testimony on the record just to make sure that you preserve it. And so they were recommending maybe you do want to depose your own witnesses. Typically, you don't depose your own witnesses. You want to make the other side do that if they choose to, but you don't want to give them that opportunity if they don't ask for it. So you schedule a deposition and you get to ask the opposing witnesses questions, and you use that to discover what information they may possess or what their testimony at trial might be. You're typically going to have this deposition reduced to writing. You're going to get a transcript of a deposition, and in certain circumstances, you can use that deposition in lieu of live testimony. But one thing to know about depositions is typically opposing counsel can ask almost anything they want. And while the attorney that's representing the witness, we call them the attorney defending the deposition, while they can object, the witness still has to answer. So there's a question, and the defending attorney says objection. They state the reason for their objection, and then the witness answers the question. The objection is noted on the record, So later on, if that information is elicited or tries to be elicited at a later date, the objection's noted and the objection's made again. In very rare circumstances, will a defending attorney say, I'm instructing my witness not to answer that question. He's not going to answer the question you ask him. We're done with that question. Move on. If that does happen, then obviously the parties can go to court and file a motion, and then they go before the judge, and the judge can decide whether or not it was a proper question that should have been asked and answered or not. Doesn't happen a ton, but I've seen it happen a little bit. So there are a few other discovery considerations. So you can go on to the next slide. We talked about before, it can be expensive and time consuming. We have to review the documents before they turn them over. It has to be noted on our privilege log if we're withholding them. This last bullet point here about using a vendor to handle the document exchange, that's different than using a vendor to help us, go through the documents for what's privileged and not privileged. If you have a particularly large volume of documents that you're going to have to send to the other party, they're going to have to send to you, you don't want to send physical copies. And electronic copies, how large are we? We're talking millions of documents. So sometimes you can find a third party that will just host those online in a secure online location where both parties can go and get them when they need them. And so that does happen in major litigation where you're dealing with massive amounts of documents that you have to exchange with the other parties. So now that we've gotten through discovery, and if you recall, we've talked about the pleading process and just getting to discovery. If things go haywire there, we can be years into litigation before we ever start discovery. Then we get into discovery. We're going to have battles on discovery. We're going to fight about the custodians. We're going to fight about the search terms. And then we're going to have to deal with reviewing all these documents to see what's responsive and what's not. So we can be a couple years in the discovery process, just getting all the documents to who needs them. And all those things. And the depositions, and getting through all the depositions that need to be taken. So we can be multiple years through this. Now we get to resolution. And you can go on to the next slide. We talk about resolution at a trial court level. Again, we'll talk about appeals in a minute. We talk about the trial court level. There's really about 3 ways you can resolve a case at the trial court level. The first is dispositive motions. And what do we mean when we talk about dispositive motions? It's a motion that asks the trial court that entirely or partially eliminates the claims in a lawsuit in favor of the party that's filed the motion. And Ms. Hampton, the question you ask about the difference between a motion to dismiss and a motion for summary judgment, we're going to talk about that right now, because those are the most common types of dispositive motions. So you can go on to the next slide. When you file a motion to dismiss, you're asking the court to kick the case for one of any number of reasons. Get rid of it. The case, they can't go forward. The most common one is F in this list. You can file for lack of jurisdiction, kick the case because the court has no jurisdiction over the subject matter or over the parties. But the most common one is F. Failure to state a claim upon which relief can be granted. It's a lot of legal words, I know. We'll break that down in some more simple language in just a minute. So you can go on to the next slide. So when you file a motion to dismiss, the motion is very simple. You just say, the defendant is asking, here in this case, the defendant, John Baer, moves this court to dismiss the complaint for failure to state a claim upon which relief can be granted, and there's an attached memo in support of this motion. And then they've scheduled it for a specific date in front of the court so that everybody knows when you want the court to hear this motion. What does it mean when you're asking the court and you're saying they failed to state a claim upon which relief can be granted? What you're doing there is you're telling the court, even if we accept all the facts alleged in the complaint as true, even if everything Goldilocks said was true, she's not entitled to relief. Just the law doesn't support her getting relief in this case. So dismiss the case. There's nothing for the court to decide here. We're done. That's the most common motion to dismiss that is filed. So that's what when you phrase it that way, that's really what you're telling the court. Typically, you file this early in the process before you even file an answer. And so that's what a motion to dismiss does. Motion for summary judgment is something different. Again, the motion is very, very similar. You attach a memo. What you're asking for in a motion for summary judgment. You're telling the court, you're asking the court to rule in your favor based on the evidence that's already presented. Well, what evidence has been presented? Well, we have things from discovery. We have documentary evidence. We have deposition testimony that's under oath. And what you're telling him is there's no genuine issue of material fact. Now, we have material facts and immaterial facts. Immaterial facts, those facts could go either way, and it's not going to affect the outcome of the case. Material facts, depending on which way they go, which is it this way or that way, that would impact the outcome of the case. And what you're telling the court is the material facts, there's no issue there. We all know what they are. We all agree on what they are. And based on those, there's no issue, there's no genuine issue as to any material fact that we know right now as we've gone through this discovery process. And based on those, there's no way the other party can win. They just can't win. So we want you to give us summary judgment. We should win now. You don't file that until after discovery is complete because you don't know any of that stuff yet. And so those, Ms. Hampton, those are the two distinct differences between a motion to dismiss and a motion for summary judgment. And, you know, the time you file them and what you're really asking the court to do with each one of them, kind of what the standards are. So those are the primary dispositive motions when you're trying to resolve a case without having to go to trial or reach a settlement. And settlement is the second most common way to reach, and maybe the most common way rather than dispositive motion is probably the most common way. And that's just what it is. The parties agree. We agree to this settlement, and we're going to get rid of the lawsuit. It can happen at any point during the suit, and it can even happen during the appeals process. And people go, why would you settle during an appeal? Well, everybody has something to lose on appeal. And if you think about it from the aspect, if there's a large dollar figure jury award and the defendant appeals that, and they take that up on appeal, everybody has a risk there. If the plaintiff has won a large dollar figure award, the defendant appeals, the plaintiff looks at it and goes, if the appellate court overturns the trial court result, I get no money without going through a new trial. So I have some risk. Is there a lesser amount I'm willing to take to avoid this and just be sure I get this amount? The defendant goes, I know I've appealed this, but I'm not sure I'm going to win this appeal. And if the appellate court upholds the trial court result, I've got to pay the full amount, plus I'm at the expense of the appeal. And so everybody has something to lose there, and so there's a lot of settlements that can be reached even during the appeals process because of that. And then you have the trial verdict. You can go on to the next slide. You have jury trials or bench trials. Bench trials are trials in front of a judge only, not in front of a jury. I personally have no experience with bench trials, so I can't comment on those very much. All the trials I've ever done have been jury trials, so I can't comment on bench trials. And those, so I would welcome if anyone does have comments on those and wants to offer those, I would welcome those.
What would be the determination of which trial type would be applicable in different cases?
I don't think there's a mandatory rule that says you can only do one or the other. I just, because I've never had any experience with bench trials, I can't even offer you strategically what would be an advantage one way or the other. I don't have that experience. So, Vicki said.
I have, and it's usually if it's a very difficult topic that juries will not understand. A lot of times it's investments a lot of times it's eminent domain, like in the governmental area. So if it's something really complex that you need somebody with a, not 12 people with a common mind, you need somebody with a more strategic mind, you'll decide to go to those. So a lot of our investment contracts, they'll try and get us to waive jury trial. We argue against that in the actual contract, but when we, if it ever gets to litigation, strategically we may decide, yeah, it's better to go before a judge only, because they'll be able to understand these concepts.
So now that we've gotten through the resolution at the trial court level, we'll spend a little bit of time talking about appeals. I don't have a lot of slides on the appeal process. It was just going to be difficult to put together some slides without getting too far into the weeds. I know we've gotten a little bit there today, but I mean, it was going to be even further than we went today, and I didn't want to do that in this setting. So the appeals process, and you can go on to the next slide. An appeal is basically what it sounds like. It's a proceeding where you've asked for a decision to be reconsidered by taking it to a higher legal authority. In Kentucky, the court structure, you have district court, circuit court, the Court of Appeals, and the Supreme Court. And so appeals are lengthy and they are expensive, but they are often necessary. We need to correct an issue in a lower court. We talked about the length when you get into the appeals process earlier. We talked about how Court of Appeals, we're talking 12 to 18 months. That's my experience. Others may have different experiences. Supreme Court can be anywhere from 6 to 9 months if they decide not to review the case, or 2 years if they decide to review the case. I asked some of our litigation attorneys here in our advocacy division earlier to give me just some of their basic time frames, and their average was 2 years, but their longest one was nearly 4 years at the Supreme Court. So, it can vary widely case by case. But the way you undertake an appeal, we can talk about that for a little bit. So if we're in circuit court and we get a decision that is appealable, and can you go on to the next slide and then we'll bounce back. We'll talk about generally what's appealable and what's not. Typically, parties can only appeal judgments or orders which settle all the rights of all the parties in the action. Orders which don't do that are what we call interlocutory orders, and they're not appealable. I mentioned earlier that there are some instances when a defendant that loses a motion to dismiss can appeal that, and some of those are applicable to unique state agencies. One of those is, and when I worked at the Cabinet for Health and Family Services, it's something we used a ton, was sovereign immunity. State agencies have sovereign immunity. And when I worked there, we would get sued all the time. And so one of our first things we did was file a motion to dismiss based on sovereign immunity. You can't sue us on those grounds. There are certain grounds where the legislature has waived that, and we can be sued on those grounds, but others they've not waived it, and so we can't be sued for those reasons. And so when I worked over there at that agency, we would immediately file a motion to dismiss on those grounds. And if it got denied, well, we can immediately appeal that. Even though it's considered an interlocutory order, it can be appealed right away. And so that's, just on this point, even though that doesn't necessarily resolve all the rights, we can appeal that immediately, because sovereign immunity as a doctrine is supposed to protect us not just from liability, but from even having to litigate at all, period. And so we would say, look, you don't have to go through this process at all. The case should be over. So if you'll go back to the next slide, so if we're in circuit court and we get a decision that we believe needs to be appealed, and it is a final and appealable decision, what you do is you file a notice of intent to appeal. You got 30 days from the date you get that order to file that notice of intent to appeal. So not a long time to really make that decision. So you can imagine if you're an attorney and you're representing a corporate entity and you need to make that decision quickly, you got to get all your ducks in a row in a hurry and get that decision made as to whether we're going to appeal this decision or not appeal this decision. You got to get that notice filed within 30 days. Once you get that notice filed, you file that notice. The circuit court gets a copy. Of course, the Court of Appeals gets a copy that, hey, we're bringing this case up to you. Then the entire record, everything that happened in the circuit court, has to be sent up to Court of Appeals because they need to see that. On an appeal, you're not retrying the case. You don't get to present new evidence to the Court of Appeals. What you're saying is the lower court made a mistake and it needs to be corrected. We need you to correct it. So you're just making written arguments and maybe oral arguments. So once that record gets sent up there, that will kick off some specified timeframes. We have the rules of appellate procedure, and those include very specified timeframes that says if you're the appealing party, you're called the appellant. The other party is called the appellee. And so it gets sent up there, and the appellant, once the record's up there, the appellant has a specified number of days to file their brief. Then the appellee has so many days to file their response brief, and then the appellant has so many days to file their reply brief. Remember early on I told you those words we would use again. And so you have a brief, a response brief, a reply brief, and then the court decides whether they're going to hear oral arguments or not. Totally in the court's discretion if they want to. In the documents you file, you do have a chance to tell the court whether or not you believe oral arguments should be had, but they're not bound by that. Both parties could say, we think oral arguments will be extremely helpful in this case, and the appellate courts could say, no, we're not going to hear it. We're not going to have oral arguments. So just because you want them doesn't mean you get them. So they may schedule oral arguments, they may not. Whether they do or don't, they will then take the case under submission, and then you wait for a ruling. And all the timing and all the rules included in the rules of appellate procedure that govern when the parties have to file this brief and then file that brief and file the next brief, none of those rules include when the court has to issue its ruling. All those rules govern the parties practicing there, but not the court. So that's what leads to the long time frames we talked about. All the briefing is done relatively early, relatively quickly in the Court of Appeals or the Supreme Court. You get it done based on these times set out in the rules, and it's over. But then the court has as long as it wants to deliberate and think about the case and issue a ruling. So then you wait. And then the process repeats itself if you're unhappy with the Court of Appeals. If the Court of Appeals issues its ruling and you don't like it, we talked about earlier, you file your motion for discretionary review with the Supreme Court. And that puts the Supreme Court and the Court of Appeals on notice. We want the Supreme Court to look at this. And if they take it, then you start back in the briefing process again. You file your brief, the other party files theirs, you get a reply, and then you wait and see if the court wants oral arguments or not. So the process is very regimented, and you go through that process, and then you wait for a decision and see what happens. So that is how the appellate practice works in a nutshell. It's way more detailed than that, and we could get way off in the weeds about things and other aspects of it. But just to understand why appeals are lengthy and expensive, the rules that govern how a brief has to be put together are very, very precise. I mean, the rules dictate the margins on the paper, the font on the paper, the spacing that has to be used. It's very, very detailed in how you have to put together a brief. And so it's attention to detail. You can't mess anything like that up. And so it is expensive, it is time consuming to go through an appeal. So that's all I have today. This detailed overview here at the end, you see at the top, we have the 4 steps we laid out at the beginning. And again, if it was just those 4 steps, it'd be relatively simple. But down below each of those steps, you see where some of the bottlenecks are, where we get hung up, where the time comes in, where the expense comes in, and the process we have to follow to get through those. And so hopefully you have a better understanding now of what litigation entails, what a lawsuit entails, and if I'm providing you an update and I tell you that we're engaging in this process, or we're at this stage, or we're doing this act, you will now have a framework to understand where along the process of a lawsuit we are. And hopefully that's helpful to you. If it's not, then I haven't done my job today, and I'm sorry for that. But hopefully it is, and if you do have any questions, I'm here. I'll be happy to answer them. If you have any questions you want to ask afterwards, privately, I'm happy to answer those as well. So,
Lynn has her hand up.
Who does?
Ms. Hampton.
Ms. Hampton, okay. Ms. Hampton, thank you.
Actually have two.
Yes,
My one question is jury trial.
yes,
I assume that there's jury trials in civil, like there are,
yes.
and if so, who decides whether there's a jury trial or not?
The parties will typically, the parties will decide whether it's a jury trial or a bench trial. I don't think that, the court doesn't have the authority to dictate that. As I said earlier, I just don't have any experience with bench trials.
What if they disagree?
If the parties disagree, I don't.
One party wants a jury trial and the other doesn't.
I think you have I just don't have any experience with that. Maybe.
The party who files, the plaintiff, is the one who gets to request whether it's a jury trial or not. And so if they want it to go to jury trial and the defendant does not, then it's going to jury trial.
Okay. And the second one is, you talked about lots of things that have 30 days and this kind of stuff, but I see trials that last 4 years, and they just seem to be stuck.
Yep.
What causes that?
Well, what causes that? A lot of times you have the 30-day deadline typically applies to the parties getting something done. There is no deadline on court decisions, and so you may have 30 days to file this document or that document and get it to the court for a decision, but the court has no deadline on their decisions, and so the case may just sit for a court decision. But there's also, in the discovery process, while the parties typically say they want these responses in 30 days, that rarely happens because the difficulty and the time that goes into responding to those. So you're always going to get an extension in responding to those discovery requests, especially the request for production of documents is going to take a long time. And so you're going to drag that out. Depositions will take a long time. If you think of a complex piece of litigation where someone needs to take 7 or 8 depositions, they may schedule those 2 or 3 weeks apart. And so you're taking 1 or 2 a month. You're 4 or 5 months taking depositions for one side of the case. What about the other side? They want to take depositions. So all of those things start to pile on and add up. And then if a case has to go up on appeal, as we talked about early on, if there's a motion to dismiss and that is granted and the plaintiff appeals that, then you have to go up on appeal and wait, and then the Court of Appeals reverses and says, no, the case should have never been dismissed. It should be allowed to go forward. Now we're back down in circuit court moving forward. And so that can result in extremely lengthy litigation.
Thanks.
Mr. Eager has a question.
Yes. Mr. Eager.
Yeah. Michael, could you talk more about attorney-client privilege, please?
Yes. Without going too far off, I'm admittedly not an expert on attorney-client privilege. We have an attorney on contract who actually teaches on this at the University of Louisville Law School. So if I have detailed questions on this topic, I typically call him. His name is Chris Schaefer, but I will typically call him for this. But just in general, I will say the attorney-client privilege will be involved and will exist when an attorney is involved in giving legal advice to the client. An attorney's presence in a conversation is not enough to create an attorney-client privilege. We were at a conference back in June, and that was something that was hammered home to us. And there was a specific case in which, at a corporate entity, certain employees would just, if they were emailing back and forth on a topic, they would just copy one of the attorneys on there and thinking that was creating privilege. But the attorney wasn't participating at all. And maybe in some instances, the attorney would chime in and say, looks good to me. And that was it. That's not enough. The attorney has to be actually involved in giving substantive advice for the attorney-client privilege to attach. And so we've always encouraged just that people are going to talk about active litigation, have an attorney present so they can be involved in giving advice about that. Otherwise, conversations aren't privileged. A mere presence doesn't create the privilege, but if we're actively involved in giving advice about it, it will. And so be careful about being involved in that. I do have one other point, but I'll take other questions. There are any others.
What's the difference between district and circuit court in terms of the types of cases?
The amount of money that's in question. And from a civil aspect, it's basically the amount of money in question. So I believe in Kentucky, it's circuit court is anything $5,000 or more. I think it's $5,000. I thought it was. I didn't think it had been raised. So if there's more than $5,000 at issue in the litigation, you're in circuit court. If it's less than that, you're in circuit court. And then if it's extremely low, you could be in some jurisdictions, you're in small claims court.
What's the path for civil cases to go to the U.S. Supreme Court?
Well, you would need to have a federal question, so you would probably be in federal court to start with.
Can you switch over? But obviously, that's a case that's being disputed right now.
Yes, you can. And so there are some instances, and I don't want to get too detailed, but there are some instances when a state court decision involves a federal issue, and then that may need to be appealed to the Supreme Court. One instance I can think of is an issue of, if you have one court that's hearing a case that is impacted by a judgment from another state.
That's true.
And then this court A in state A is saying, we don't care what they decided, we're doing our own thing. Well, you might not be able to do that. And if they continue to ignore that, then you may have to take that up to the Supreme Court, because that's a federal constitution issue. So you may have to take that to the U.S. Supreme Court to get the United States Supreme Court to say, no, the federal constitution prohibits that. So there is a path for state court decisions to get there, but it's not a super common thing. One other thing I wanted to mention, and I thank Vicki for making this note and reminding me, is when a lawsuit is filed, sometimes even before it's filed, if an entity anticipates litigation may be filed. If you know that something is coming, it's just not been filed yet. Then what needs to happen needs to be issued is what we call a litigation hold, and that is a notice that goes out to members of the entity, employees or other members who may have relevant documents. We call that a litigation hold, and that goes out to tell them, you may have documents that are relevant to this litigation, either the litigation that's been filed or we anticipate is being filed. And you may have relevant documents. You are hereby notified, you can destroy nothing. You can't destroy it, you have to retain it. And so that's what we call a litigation hold. And we notify them not to do that. The result of if something is destroyed, if a plaintiff files a lawsuit and they request documents that they know existed, and it comes out that those documents were destroyed and they can't get them, then the judge can tell the jury, you're free to assume what was in those documents was damaging to the defendant's case. It's called what we call a spoliation instruction. They destroyed those documents, so you can assume the contents of them would be harmful to their case. And so you send those those litigation hold notices out to ensure that doesn't happen. So, and that is one of the reasons, if you've heard me speak at all, that is one of the reasons that I harp a lot on personal email issues. We as an agency, we can't always ensure that personal emails are retained. If it's something in the KPPA umbrella world, even if delete is clicked, we can ensure it's retained. But we can't always ensure that in someone's personal email. So that's why we always harp on do our business on our stuff, so we can ensure that. Anything else? I'm happy to answer any more questions.
Excellent, excellent.
Thank you.
Good discussion.
Thank you guys so much. I really do appreciate your time. I'll answer any other questions. If anyone has anything privately, let me know. Thank you all again for your time and attention. I really appreciate it.
Thank you very much.
Thank you.
Thanks.
I will adjourn the CERS board if there's no other questions for Michael. CERS is now adjourned.
And the same message to KRS trustees. Are there any questions, Michael?
I do just want to note, Ms. Hampton, that Ms. Eves was able to get on early on in the presentation, so I do want to note her presence here for her education hours today.
Thank you very much. I think she might be the one person that might not have needed everything that I did. So, especially Michael and Vicki, thanks to you all for everything you did and for the interesting case that we were studying against the bear.
Yes.
So thank you for putting that together. Okay, so with that, I adjourn the KRS meeting, and again, thanks.
Thank you.